नमस्कार सभी का एंड वेलकम आज के सेमिनार में जिसपे हम बहुत ही एक इम्पोर्टेंट टॉपिक पे डिस्कशन करने जा रहे हैं विच इज डोमेस्टिक वायलेंस. So tonight's session will be led by our AHA president Amendra Singh ji. We all know him as a president of AHA. I would like to just give a brief introduction about him. So Amendra ji was admitted as a lawyer in New South Wales over 32 years ago in 1992. And he has spent his early career in NSW government in roles like the Deputy Registrar of Industrial Registry, prosecuting lawyer with the Department of Industrial Relations, and senior prosecuting lawyer with the Work Cover Authority. And he has also worked for the Office of the Director of Public Prosecutions. 2005 May, he was admitted as a barrister. As a barrister, he's an advocate who specializes in appearing in court. Amendra ji often appears in criminal jury trials, both as a defense counsel and as well as a crown prosecutor. He also regularly appears in family law trials involving property and parenting disputes. So आज के topic पे today's session we will discuss the far-reaching changes that are being made to domestic and family violence laws in Australia. Amendra ji will cover the below points and will give us an insight into how this area of law works and the changes that are coming into effect. His talk will explain what are apprehended violence orders, their benefits, their dangers, what role family violence plays in family law, parenting, and property proceedings, and criminal offenses involving domestic abuse. इस सेशन में हम और भी पॉइंट्स पे डिस्कस करेंगे, इंक्लूडिंग न्यू क्रिमिनल ऑफेंस of coercive conduct, new definition of domestic abuse, and changes in the Family Law Act, codifying how domestic violence can give the victim of domestic violence a greater share in a property case. So over to Amendra ji.
Thank you, Navodita ji. And sabko Ram Ram or Namaskar. The topics are set out there in summary on that page. I want to start with by explaining the different areas of law where domestic violence plays a role. So you'll see that the first one is AVOs, Apprehended Violence Orders, and they are governed by state laws. They are civil proceedings. The second area is criminal charges, also governed by state laws. And the burden of proof is different. It's beyond reasonable doubt. The third area that it applies to is in family law parenting, and that is a federal jurisdiction. And finally, the fourth area it applies to is family law property matters. Again, it's a federal jurisdiction. Importantly, there's a lot of overlap between all these different jurisdictions and causes of action. Now, you can see from this table here, firstly, that about 64% of family law cases, there are allegations of domestic violence. So it's a very, very large number. 2 out of 3 cases, there are allegations of domestic violence. And if you look at the statistics for New South Wales in crime, you will see there's a total of about 190,000 cases of domestic violence in the last year. So that's a very, very large number. And they're set out in that table. The serious ones are of a much lesser number. For example, if you look at the last figure, DV non-criminal, 85,000 are non-criminal. They're simply AVOs, where individuals apply for AVOs against each other. Now, there's a new law that's come into effect from the 1st of February 2024 in New South Wales, and it is similar to other state jurisdictions, where a new definition called domestic abuse has been brought into the law. And this slide sets out what it is. The first one is fairly straightforward: violent or threatening behavior. The second is coercive or controlling behavior, which is a widening of the law. And the third one is causing fear for the safety of well-being of others. Now, when you go to the next section, it gives examples of what is domestic abuse. Physical abuse, that's fairly straightforward, understandable. Sexual abuse, violent behavior, understandable. Then we have economic or financial abuse. That is a new area of the law. That is an area where what we now have is that what was previously part of family relationships, arguments between parties, is now coming into criminal law. And the line is blurred. Where does an argument in a family stop and a criminal offense is committed? Then you've got verbal abuse. So domestic violence is not just physical violence. Any form of verbal abuse is domestic violence, and behavior that shames, degrades, or humiliates. Also intimidation, which is what it means. It's trying to intimidate someone. I'll just go back to where I was. So then the next slide gives more detail as to what may constitute domestic abuse, stalking, etc. And this is another new aspect of the law. If, for example, someone is following you, using technology, tracking you, or otherwise monitoring you, that is domestic violence. That's another form of domestic violence. Damaging property is domestic violence. And also, if you hurt an animal, even though you do not hurt the other person, if you hurt an animal, that is also domestic violence. Then you have, again, the widening of the definition of domestic violence, stopping someone from seeing their family, friends, not letting them participate in ceremonies, etc., or expressing their cultural identity. And then lastly, where you deprive a person of liberty to participate in their day-to-day activities. And again, that's where there's a blurred line between what becomes a criminal offense or a civil AVO and what happens in day-to-day families. So, for example, if someone is not allowed to go shopping, not allowed to have a driver's license, not allowed to have his or her own bank account or access to it, these are forms of domestic violence that the law now recognizes. And then lastly, if a child is present, the child doesn't have to be harmed or attacked or addressed. If the child is in the presence of where domestic violence occurs, then that is another form of domestic violence. Importantly now, the domestic violence can be what's called a single act, or it can be a combination of acts. So, for example, if, for example, a person says, well, look, in 2020, you shouted at me, you yelled at me, you called me names. In 2021, you did not allow me to operate my bank account. And in 2022, you did not allow me to meet my family in India. You stopped me from going. What the law now is that you can use that combination of different forms of domestic violence to make a case of domestic violence. So it is a considerable widening of what is domestic violence. And it's really, really important for people to understand that. Now, here it gives some examples of what it is. So the example is if you withhold financial support, if you stop a person from employment, if you control that person's income, etc. So if, for example, one party does not have access to joint bank accounts, does not have his or her own bank accounts, that is a form of domestic violence. Then when you go to other examples, they go even further. For example, making unreasonable demands about the person's personal, social, or sexual autonomy. Now, what that means, for example, is if one party in a relationship is having an affair with someone else, you can't force that person, you can't stop that person, you can't make remarks against that person. The law says, and what the law now is, that that's that person's sexual autonomy. And that's a really big increase in the scope of domestic violence. The next one is fairly understandable, and the last one is also straightforward. So if I go to the next one, there's now a new criminal offense. It's called abusive behavior towards intimate partners. And an intimate partner is someone who's 18 years old or older, married in a de facto relationship, and C, does not have to be in an intimate relationship or a sexual relationship. So it extends to someone who might be a flatmate or someone otherwise close to that person. Again, a widening of the law. So this again mirrors to a largest extent the definition that I've gone through. It includes a course of conduct. It includes coercive or controlling behavior, and it relies on what a reasonable person would consider is domestic abuse. So you may not, or the parties may not think it's domestic abuse, but the law looks at the reasonable person, the reasonable Australian, what he or her feels, and if that is regarded as domestic abuse, then it is abusive behavior. And importantly, it's a criminal offense which carries a maximum penalty of 7 years. It's a very serious criminal offense. And it's the first time such an offense has been created anywhere in Australia. Then it goes on to the law sets out, but I'm not going to go through all the details. It's same thing. It goes on. It can be a combination of conduct, defenses. That's a legal technical term. I won't go into that. Again, when you look at the definitions, it's very similar to the definitions in Section 4. Violence, intimidation, coercion, and control, causing harm to a child. For example, subsection 54F2A, behavior that causes harm to a child if a person fails to comply with demands of the person. So, for example, if you tell a child, look, if you don't eat your dinner, I'm going to belt you, and the child feels aggrieved about that, and he goes to his or her school and complains, you can have you can have a charge or allegation of domestic violence against you. That is how wide the law is. So people need to be really, really careful in their dealings, not only with their spouses, but also with their children. It's often the case that children go to school, they make a complaint to someone, they tell a friend, or they tell their teacher, and there is mandatory reporting. As soon as any allegation is made, there's mandatory reporting. It goes to docs, it goes to police, the child can be taken away, and the parents can be charged. And I'll give some examples shortly about what can happen. So I'll just finish this part of the section. It can be directed to another person, and again, economically or financially abusive. And that's a strong theme now, that every person must have full independent control of their finances. Now, it's the case in many families that one person manages the finances. That's all fine, as long as the other person has access to finances. You can't have the situation where one person controls all the finances. If there's a dispute, if there's a disagreement, the other party goes and complains. It is a form of domestic abuse. Again, exactly the same definitions about financial support, keeping employment, etc. Behavior that shames, degrades, or humiliates. For example, if you say to someone you're fat, or you say to someone you're anorexic, you say to someone you're a retard. These are all examples of domestic abuse. You can't do that. You can't say that. Monitoring, we've been through that already, exactly the same provision, and also the other provisions mirroring the definition that I went through with you. Injury to animal, again, same thing. You can't injure an animal. Again, meaning of sexual behavior, the definitions, as you can see, mirror the definitions in section 4. So they are exactly the same, so I won't repeat them. Course of conduct, same thing. It can be a one-off incident. It can be a continuing course of conduct. It can be repeated acts, the same act, or it can be repeated different acts at different times. So it's a very, very wide definition. And I'll give some examples at the end of the dangers of what can happen when relationships break down. And it applies to this state, and it applies to another jurisdiction. So, for example, if you go on a holiday in India and there's an allegation that there's some domestic violence, you can't say, well, it happened in India. The law says it includes what happens here and what happens in other jurisdictions. Okay, these are the procedural requirements. I won't bore you with that. I'll just go on to the Family Law Act. But before I do that, I just want to give a couple of real life examples. There was one case where there was a teenage girl who was sending photos of herself to males or adult males, and the parents found out. So the parents disciplined the child, they hit the child, and the child went to school. The child told a friend, the friend told another teacher, and the teacher reported it to docs. The mother was a registered nurse. The father was a security officer. The child was taken away from the family. Both parents were charged with criminal offenses. The parents went to the school and they made full admissions. They said, yes, we hit her. She did this, we hit her, we disciplined her. So they made full admissions and they were charged. So that's one example of, it's not necessarily your form of what we understand of traditional domestic abuse, but how you need to be really, really careful that you cannot cross the line. The law is so strict. And this is, I'm just giving one example. There are dozens and dozens of similar examples. Another example is, and that's another very common example. A person rings the police, rings 000 and says, my husband is hitting me, he's strangling me. The police come, take the husband away, arrest him, charge him. And then the next day, the wife goes to a lawyer and says, look, that didn't really happen. We had an argument, bit of pushing and all that, but I want to withdraw the charge. Well, you can't withdraw the charge because the charge is laid by the police. So what happens in many cases is allegations are made. We don't know where the truth is. Unfortunately, people go there without legal advice. They make admissions. Even if you admit pushing someone, that's an assault. So you made an admission. So I really want to emphasize that whatever you do, if your children or your siblings or someone in your family reaches a stage where the relationship is having problems, what they need to do is either get help, get counseling and resolve it, or separate, because that is where the bulk of the problems arise. And once that happens, the consequences can be really, really harsh. You have people ending up in jail. You have people who cannot see their children, people who spend hundreds of thousands in legal fees. It's really, really important to get legal advice as early as possible. Whatever you do not go to Indians in Melbourne or Hindus in Sydney and ask, what should I do? Because invariably the advice you will get from these bush lawyers will be the wrong advice. So if any of your friends, family, whatever, are in this situation, or if a person is a victim of domestic violence, there's a proper way to do it. Make an honest complaint, tell the truth, and you can't go wrong. I now turn to the Family Law Act, and there's a very close relationship between AVOs, criminal charges, and family law proceedings. There's always an interrelationship. And often people don't know the consequences of what they do. Someone might say, well, there's an AVO against me, I just agreed to it, I don't want to pay a lawyer. Or there's a criminal charge that I assaulted my wife, I'll just plead guilty. But it has consequences. Because when you go to the Family Law Act, family violence, the protection of children is paramount. And if there's any allegation of domestic violence, it can have serious consequences. If it's a serious allegation of domestic violence, then that parent will not have access to the child. The court will order that if there is a risk of serious harm to the child, then that parent will not be able to see his or her child. And the other thing is that it's not only males that engage in or alleged to have engaged in family violence. A significant number of females, allegations are made against them. And in many cases, there are counter allegations. Both parties allege allegations against each other. So when you look at the definition of family violence in the Family Law Act, you see the similarities there. How the definitions are very, very similar. Assault, stalking, derogatory terms, malicious damage, injury to animal, financial autonomy, financial support, stopping connection with family, and unlawfully depriving a family member of his or her liberty. So the law is comprehensive with the AVO law, with the criminal law, and family law. They all have similar principles. That domestic violence is not just physical violence, it is a much wider definition that covers all kinds of conduct, including financial conduct, social conduct, your freedom of movement, etc. And other examples that are given here is, but this is particularly related to children, where children are not the victims of domestic violence, but they hear, witness, or see them. For example, they hear about their mother being assaulted. Their mother has been assaulted. She comes to the child comforts her. That's a form of domestic violence for the child. One party throws and breaks the dishes. The child has to pick and clean it up. That's a form of domestic violence. The ambulance are called. The child's mother has been hurt. The child witnesses it. That's a form of domestic violence. So then how does all this affect family law proceedings? So the court in family law parenting proceedings must consider the safety of the child and any person the child lives with. So if there's any risk to the safety, then the court might not allow the other party access, or may order supervised time, or order limited time with the child. And again, we go back to what's happened in the past. If there's an AVO against a party, that is prima facie evidence of domestic violence. If a party has pleaded guilty to a criminal charge, well, that's prima facie evidence of domestic violence. Now, the last matter that I want to address, and which is not really known to a lot of people, but it's a really, really important part of family law. There was a case called Cannon and Cannon. And Cannon and Cannon decided that in certain circumstances where there is a history of domestic violence, the party who is the victim of domestic violence will get an adjustment in his or her favor. Now, there are three requirements. There has to be a course of conduct, usually over a number of years. They need to contribute to the victim of domestic violence, having her contributions being more difficult. Now, one doesn't need psychological evidence. If, for example, a person has been bashed, physically bashed, gone to hospital, it's happened 3 times, that's prima facie a Cannon adjustment. The violence had an impact on the victim's contributions. And so I'll give 2 examples shortly. So it has to be of a type that affected that person. Again, you don't need medical evidence, you don't need psychological evidence. The conduct itself, the court will be satisfied whether or not it's affected the party's contributions. Now, for example, one person, 2 people are married for 20 years, and the wife says, look, for the last 15 years, every year, every second year, my husband would hit me, he'd punch me, he'd strangle me. I called the police on numerous occasions. He was charged once. And on the last occasion, he hit me with a cricket bat, and I suffered a bruise to my head. Now, that's clearly a case of a Cannon adjustment. I've got no doubt the court will give a Cannon adjustment. Now, it will be a significant adjustment. For example, if there's a property pool of say, an average property pool of 1 million, and in a long marriage, the court says, well, it's 50-50. Let's the children are grown up. There's no other adjustments. Each party should get 50-50. But then the court says, well, this woman for the past 15 years has been suffering domestic violence. I will give a 10% adjustment. So what happens is that the victim of domestic violence will get an extra $100,000. And that will make a huge difference to her, because it may allow her to buy the family home, may allow her to buy her own unit. So that's one example. Another example could be there's no police report, there's no hospital record, there's no other evidence, and suddenly the partner or one of the parties says, look, I've been a victim of domestic violence. My husband used to swear at me. He used to call me names. He did this, he did that. He used to slap me. He used to hit me. And then it's a matter of evidence. The court has to be satisfied that there is sufficient evidence. Now, if there isn't any other evidence, if it's just what the woman says, she's never raised it before, it might well have happened. But in the absence of evidence, the court may say, well, we are not satisfied, and I will not give you an adjustment. So those are two examples of how the canon adjustment can play out in real life. So that's all I have to say. And most of you know that we've got the Hindu Legal Helpline, and it's for these kinds of cases that we've set up the helpline. People who are suddenly victim of domestic violence, they get kicked out of their house. They don't know what to do. They can, if you're an HA member, you can ring me directly, or you can contact the helpline. Someone is kicked out of his house, charged with an offense or AVO. He or she says, look, it's false allegations. Contact us as early as possible. Before you speak to the police, before you speak to the school, before you speak to anyone. Once you've done all that, it becomes much, much harder. All right, so that's what I wanted to say today. If anyone has any questions,